Good evening, students. So today we'll be discussing an important topic related to education, that is Right to Education Act 2009. As we all know, in today's life, education is the basic need of every individual. It helps to build your mind, your personality. So we'll be discussing about it, the laws, and what our constitution holds about it. So let's get started with it. So, Right to Education Act 2009, we start with here how education is made a fundamental right with evolution of the country. Okay, so we go back to 2002 to 86th Amendment Act. We see that the education uh, has been made a fundamental right through 86th Amendment Act. Yes. So 86th Amendment Act, education has been made a fundamental right, and sub-clauses added to Article 21A, where education was made a fundamental right, the basic right to acquire to every citizen. And there should be a free and compulsory education. Free, that is, no money is to be charged to the children from the age group of 6 to 14 years of age. So this education is free and compulsory. And in case of disabled people, the age limit is 6 to 18 years of age. Now, disabled people who have any bodily infirmity or deformity or any mental deformity, so these people are termed as disabled or can be said as differently abled. So these people are given the right to acquire education from 6 to 18 years, free and compulsory education from the government. Before that, before 86th Amendment Act, Supreme Court in the case of Mohini Jain versus State of Karnataka 1989. Supreme Court in this case only earlier said that right to education is included under right to life. That is Article 21. Article 21 is right to life and personal liberty. So in this case only, before this 86th Amendment Act, before the introduction of Right to Education Act 2009, all these things, Supreme Court in this case, Mohini Jain versus State of Karnataka, 1989 stated that right to education is included under right to life. Then if we say, see, that education comes under concurrent list. If you remember, we have three lists: union list, state list, and concurrent list. What are these lists about? That the laws made by the government, if the parliament makes laws, parliament can make law under union list. If states want to make laws, state parliament, state with legislative assemblies want to make laws, then they have to make laws under state list. And concurrence list here stands for the laws made by both union and state. So the topics, the list says that whatever in this list is there, the union and state both can make laws under this. So education is the one thing where state and union both can make laws, because it's a very important and very deep important topic related to the human race. Okay, so and through this 86th Amendment, Article 51A was also added. Now, what this Article 51A says, it states the duty of parents and guardians, where these parents have the duty to send their children to the educational institutions. Now, there are many people, there are parents who do not send their children to the education institutions because uh, maybe they do not have the resources to send them, or maybe they are that poor that they want their children to work in the factories, or introducing child labor and everything like that. And if we talk about people about the girl child, so people think that these girls do not need to be educated. So there are many things, seeing all that accordingly, Article 51A was added through 86th Amendment Act, where it is a duty of parent and guardian to send their children to the this educational institutions. Okay, public government educational institutions. Then further we have what was there before 86th Amendment Act. First, we have seen that case, Mohini Jain case. where Supreme Court said that it is the part of the personal liberty, life. But before that, what we can say that at the time of independence, we do not have any provision related to education. No, that was not the case. We had the provision related to education, but it was mentioned in Directive Principle of State Policy under Article 45, Part 4 of the Constitution. It was not the fundamental right, it was Directive Principles of State Policy, which means it was directive. It was not mandatory. State was directed that when they have the resources and if they can, so they should try attempt to provide education to these children from 0 to 14 years of age. So 14 years of age, it was not mandatory, but it was said that states should try and attempt to provide this education. So it was under directive principle of state policy because of the least resources in the country. Then it was also said free and compulsory education if the resources are enough. These rights are not enforceable, not justiciable. That means you cannot go to the court and enforce them. If any institution is not providing you with education at that time, before 86th Amendment Act, you were not allowed to go to the court and ask for this, because it was not your fundamental right, but was just a directive principle, and directive principles are non-enforceable and non-justiciable. Then after this, after 86th Amendment Act, an amendment was made to Article 45 also, where it is stated, see, the education of children were made as fundamental right under this 21A. But in directive principle, what changed? This provisions changed. This was given to the fundamental rights, and a new provision was added, that is early child education. Below the age of 6 years, children, it is known as Anganwadi. These children were given this early child education termed as Anganwadi. Okay. So directive principles have this thing now, and the education, compulsory free and compulsory education is given to the fundamental rights under Article 21A. So here we have Article 21A. Just we need to know about this is it is added by 86th Amendment Act 2002. It is enforceable by the court. That is, if any institution tells you that you do not have any right to study there, then you can go to the court and make it enforceable. Okay, you can ask for the damages, you can ask for the compensation, and ask that you have the basic right to get education from that institution. It is a part of fundamental rights. Part 3, that is fundamental rights are enforceable, and you have all the right under Article 21A, that is right to life and personal liberty. Then moving further, what we have, yes, Right to Education Act 2009. Now, after all this chaos, after 86th Amendment Act, after addition of Article 21A, 51A, all this Right to Education Act 2009 was enacted. On 1st April 2010, it came into force. It was enacted on 10th of December 2009. It is said 2009, but it came into force in 2010, 1st April. Okay, and India became the 135th country to have its own legislation related to right to education. Okay, 135th country. It initially had 7 chapters and 38 sections. Then some provisions related to this. We'll discuss about it. So there's one of the provision where it says age-wise homogeneous. Now this means that for example, a child who is drop out from school, for example, he has studied till 5th standard and then he dropped out. He started working with his parents for his living, and now after 2 years he wants to enter the school again. So he must be in 7th standard, but he has done his study till 5th standard. So this provision says that that person, that child, will be admitted to 7th standard only, but not to 5th standard. If he needs some special training or other things, that will be provided for the time limit, but he won't be now given the class of fifth class. He'll be admitted to 7th standard only, because it says that it's an elementary education. When the person grows, the mental ability of people increases only. However, he must have not gone to school, so he can cover up through special training, but this won't happen that the person will be admitted to 5th standard only. Then no detention policy 2019 amendment, it was said that any no person will be backed out, that is the no child will be considered as failed. If that person has failed, a new examination will happen for him or her, but the person will not will be considered to be failed. Then some more provisions, if we see, there are some prohibitions under this act. So what are those prohibitions? Physical punishment and mental harassment. See, if you watch old movies, you must have seen there is a master G and a student, and he has that chhari and beating that child if that person is not able to cope up with the studies. So it is said that physical punishment, mental harassment makes people confidence, the children confidence low, and this should not be the case. The teachers should have patience so that they can teach the children correctly. So this is prohibited. You cannot physically punish or mentally harass the child. Then screening procedures for admission of children. If, for example, the person is not able to clear the qualifying thing, then you can say that you won't be admitted. You have to make it is the duty of the teacher to teach and give the special training to those people. Then capitation fees 25% of economical weaker sections. See, all whatever we studied about, it's about the government school now, but the capitation fee of 25% to economical weaker section under section 12, it says that private institutions also will have this quota of economically weaker section by 25%. Then private tuitions by teachers are not allowed. The government teachers are not allowed to take private tuitions, because there you can see we have the cases where these teachers say that I'll be teaching you, I'll not be teaching you in the classroom itself, but if you will come to my coaching centers, then I'll be teaching you in that way, and I'll be giving you marks, and various other corruption things are we have in a country. So it is prohibited. Private tuitions by government teachers are prohibited. Then running of schools without recognition is prohibited. It should be affiliated, as you know, CBSE, ICSE, UP board, or MP board. All these boards, every the school should have recognition, so it should be affiliated with all this. Then some other provisions of RTI Act is ratio of teachers. Now it is said that if we see primary classes ratio of teachers up to 60 children, if there are 60 children in the classroom, there should be 2 teachers. Then 61 to 90, there should be 3 teachers. Then 91 to 120, there should be 4 teachers. And if it is more than 150, above 150, 5 teachers plus 1 head teacher. It is said that if this is not able to comply with, people are not able to comply with it, it should, if students increase by 200, then at least there should be a ratio of 40:1 teachers. So this is a thing. However, in papers it is different, in ground reality it is different, but this is in the act which is it is stated. Then if we talk about building, it is said that at least 1 classroom for every teacher should be there. Then office come, store come, head teacher's room. There should be a staff room type for the head teacher. It should be a head teacher room. Then a kitchen. Kitchen for midday meals in 1995 it was originated that midday meals should be provided to the children coming to the schools. So a kitchen should be there for this midday meal. Then separate toilets. Spelling, you can see the spelling, you can correct it. It's toilet for girls and boys should be there. Then playground should be there. Safe and adequate drinking water should be there. Yeah. Then just a second. Then primary school, it is also noted that primary school should be within 1 kilometer of the person's home. Then upper primary should be within 3 kilometers. See, if you remember, our parents should be say that we should go this miles to get the education and everything. So that was true. The schools were so it was not so close, so people were not able to have their education. They were not able to complete the education. So this is a provision there that primary school should be of within 1 kilometer and upper primary within 3 kilometers, so that children can go to school and acquire the education. Then there is some provision related to minimum of working days. See, first to fifth class, the working days of the teacher should be 200 working days. If we calculate in hours, it should be 800 hours. Then 6th to 8th class, 220 working days. And if we talk about hours, 1000 hours. Then minimum number of working hours per week of a teacher should be 45 hours, including preparing hours. These are the questions asked in various examinations. So you should go through it. Minimum number of working hours should be 45 hours. The preparing hours, making lesson plans and everything, this can be included in these 45 hours. So I think we complete our Right to Education Act. I hope you have a great learning. Thank you for attending class, and yeah, have a great day and goodbye. Study well. Thank you.